Thank you. Hello. So, good evening, everyone. And it is a great pleasure to open this webinar of the Italian branch devoted to various aspects of international litigation under this COVID-19 pandemic. First of all, I would like to thank all those who have made this possible: Attila, Tanzi and his group, Gian Maria Farnelli, Marco Argentini, and of course our communication officer, Mariangela Lamanna, and panelists, discussants, and all of you who have taken your time to be with us now. I think this webinar format is particularly suited to the activity of the Italian branch because we are part of the International Law Association, an international association, and we all know that in all branches there are competent and outstanding and eminent scholars and professionals who may give a great contribution to discussions in conferences, seminars, meetings. But it is difficult to get them in Italy because they are very busy. And of course, for them, it may be impossible to take 2 days, take a plane, stay overnight to participate in person. So now the circumstances have prompted us to go to the web, but I think that we should take the opportunity to plan further activities on the web. And for this reason, I really encourage all our members to put forward ideas, proposals for further seminars. And Alberto Malatesta, our Secretary General, and myself will be delighted to support these initiatives as much as possible, as far as possible. But I don't want to take more time away from our discussion, and I give the floor to Attila for his introduction, please.
Well, thank you very much, Gabriela, for having very kindly asked me to moderate this webinar and for having had the idea to have this seminar. And allow me to echo you on thanking the speakers, discussants, for having made their time and knowledge available for us today. And let me also thank the members of the audience for their virtual presence and for possibly stoking the discussion during the question and answer session. I remember, Gabriele, when we first discussed the idea of this event, it was a month ago, and it was under a very different atmosphere from now, at least in continental Europe. We were fully aware that many like events would have flooded the web, and that has been very much the case. But rather than trying to break the record of promptness, we would rather let the events and the debate unfold so that our speakers today and discussants could take stock of the factual on the one hand and scholarly relevant developments on the other. And indeed, since then, developments galore may well stoke today's discussion. Well, in my moderation, I will have to exercise a margin of caution as I'm currently involved in arbitral proceedings, which inevitably come down to assessing the lawfulness of state regulatory powers. Now, apart from the unique fact-specific nature of any given case, I suppose no issue of conflict may arise from an academic illustration of the litigation sceneries that have been so far portrayed in an online debate that has been very, very intense. And it is actually emerging also from the first domestic and international cases. Can you still hear me? Can you hear me?
Yes, Professor Tanzi.
Yes.
I will very
mute myself.
shortly emphasize by way of introduction 3 general features that seem to me to have emerged out of this debate. The first feature seems to be the formidable width of the scenery of potentially disputed facts, which for purposes of international law include domestic legislation, regulatory and implementation measures. This scenery ranges from stringent emergency sanitary measures on the one hand of the spectrum to the lack or the alleged too lenient nature of measures on the other end of the spectrum. Now, the width and complexity of the potential litigation scenery in question sensibly increases if one includes, and I suppose one should, not only state conduct adopted at the time of the health emergency, but also conduct aimed at curbing the major economic consequences of phase 1. Now, based on the ongoing discussions, I will single out few potential causes of action that may steer COVID-19 related litigation, focusing on those having an economic slant next to measures impinging on personal freedoms. Suspending certain business activities only, where the dividing line between strategic and non-strategic businesses may give rise to controversy. Similarly, providing for indemnity for extraordinary losses to certain companies active in certain sectors rather than others. Financial measures benefiting only national companies, including state aid. We heard yesterday about Lufthansa being significantly helped by the German government. We heard today the French government helping the car industry, just to mention 2 most recent cases. Then we have the golden share mechanism. Some have even evoked binational campaigns, forms of requisitions, bans on imports, but also on exports of sanitary products, for example. Suspension of loans and mortgages, imposing caps on tariffs for public utility services, suspension of domestic judicial proceedings, allegedly impinging the right of access to justice. Just to mention some that have been evoked in the ongoing debate. Now, the second feature, as I see it from the hypothetical causes of action that have been just described, is the overarching relevance to different litigation contexts of similar or the same facts. At the international level, we find international human rights courts, international investor-state arbitration tribunals, but also domestic courts, where international law may be litigated, in order for the grounds to be perfected for a case to be brought on the international litigation level. This obviously applies where the exhaustion of local remedies is required. But I would add international commercial arbitration, where the claim is based on state contracts. Last but not least, I would look at the WTO litigation context, despite the well-known uncertainties about its operative future against the United States obstructions. The third and last feature is the cross-cutting relevance of potential defenses by respondent states. We find much the same matrix operating with different calibrations on the international contract level, human rights conventions, international investment law treaties, WTO covered agreements. They all operate in a two-pronged manner, either by way of some sort of national security treaty or contract provision, or by way of some common law, statutory law, or international customary law. It will be interesting to see whether the future case law may determine by way of interpretation the confirmation or development and transformation of such basic international legal and domestic legal institutions alike. Now, I have two housekeeping announcements to make before we get started, really. We are under audio-visual recording. which accounts for my caution particularly, and those of my colleagues. And for those who are interested, please digit the tab chat or lift your hand to be put on the list of speakers during the question and answer session. Now, prior to getting to litigating COVID-19 related disputes, Ali Malek, Queen's Counsel, has kindly accepted to share his intense experience about litigating at the time of the lockdown, actually when he himself was under major COVID-19 symptoms. It will be interesting to hear his views about virtual hearings and about whether this emergency mode may impact proceedings in the future. Ali Malek is a leading silk at the Commercial Bar. He has been chairman of the Commercial Bar Association, a member of 3VB in London. Alongside his extensive litigation practice before domestic courts in London and foreign jurisdictions, is a specialist in international arbitration, both commercial and investor-state arbitration, both as counsel and as an arbitrator. He's authorized to sit as a deputy judge in the High Court. Given time constraints, I will skip most of the many feathers in Ali's cap, but I wish to mention what I regard as the genuine link between Ali and public international law. Namely, he has been the pupil supervisor of Judge James Crawford during his pupillage at 3VB. Now, without further ado, Ali, I'm pleased to give you the floor.
Thank you very much. First of all, can I say how privileged it is to be with you this afternoon, and also to, I suspect, the cause of why the seminar's in English, but that's another matter. Very embarrassing that we're so bad at foreign languages. So as Attila said, what I want to do is just explain to you what COVID-19 has done in terms of litigation and arbitration. And as Attila said, I've come across this in a number of contexts. First of all, in the commercial court financial list, then in the relation to in Qatar and the international court there. I'm in the midst of a financial markets tribunal in another Gulf state, and I've also done a hearing, an arbitration under LCIO rules. So I've got some experience in terms which I'd like to share with you in terms of how these proceedings take place, and of course they're important because we're not just simply concerned with substantive law. We're concerned with how rights are actually invoked and what in practice happens. The case that Attila mentioned is quite interesting because it was the first case where we had a virtual trial. I mean, taking evidence by video conference is not unusual. We've done that, and I'm sure you've done that in many cases. But with the COVID-19, we were faced with effectively doing nothing for very many months while we're affected by COVID-19, which of course has an impact on the administration of justice, the rule of law. And of course, if we don't have hearings, then we're going to be faced with a massive backlog. So in my case, the case was coming up for a hearing, and this must have been about 10 days before the hearing, when one of the parties asked for the hearing to be adjourned. The argument was that the witnesses are going to be coming from Kazakhstan, from Brussels, from America. It was wholly unfair to expect a trial to take place. The witnesses and experts could not get to London. No one would be prejudiced if there was a delay and the hearing was to take place a few months into the future. We opposed it. We said no. We said the case should go ahead, that it's important that it was a big claim. The claim was for some $500 million in relation to monies held in a London bank account. And we said that the hearing should take place. And the judge said yes, because we were quite lucky in the sense that a number of statements had been made by the senior judiciary that we were going to get on with things. And that's basically been the theme of what's been happening in London, which is that we're trying to do virtual trials wherever possible. Some cases it's not possible to do it, and perhaps we can talk about those very briefly a moment later. But in any event, the case went ahead. One of the objections to the hearing was that the lawyers on the other side said that they'd been in contact with people who'd had COVID, and what would happen if somebody got COVID-19? What would happen in those circumstances? Well, the judge said, well, somebody else can argue the case, which is not very practical, but anyway, is a one way forward to do it. And in my case, as Attila said, I actually went down with COVID-19, which was, I had a temperature for about 10 days, not too bad, but we have this kind of philosophy. I don't know whether this is an English thing or whether in Italy you're the same, or whether you just jump straight into bed. But the thinking is that if you can get to a court, you get to the court. And of course, when it's being done virtually, what you're talking about is moving from your bedroom to your study in order to address the judge. And that's what I did. I mean, it wasn't very easy. It was, but it happened. And anyway, the trial went on, and it went without a hitch. We used Zoom. We had a platform provider called Spark, and we took evidence from, there was factual evidence, there was expert evidence on Kazakh law taken from a professor in Kazakhstan. One of the experts was in fact in the United States, and we took evidence from him. And then there was evidence from two experts on Belgium law. And frankly speaking, it works. I know there are concerns about virtual hearings and whether they are practical. I mean, we were fortunate in the sense that we had well-resourced parties who could afford to put on this matter. And as I said, we used a professional platform provider for Zoom. And it's not just Zoom. We've Skype for Business, Teams. I've used Cisco WebEx, GoToMeeting. I think I've used Blue Jeans. I mean, I don't think it really matters. But anyway, the trial went ahead, and we had the evidence. We had closing submissions. We dressed up. We don't wear wigs in court, contrary to popular thinking. So there wasn't an issue on that. But it was fine. And there are problems in the sense that you're on your own. When you're in court, you're in a team. And there were a lot of people in the case, and we exchanged ideas using WhatsApp. So you do need to have some kind of means to communicate with each other. And as I say, this is what is happening in London now. Now, there are certain issues that arise that one needs to keep in mind. We have a tradition that hearings are in public. And the question is, well, how can a Zoom hearing be in public? And we solved the problem for the first day anyway, on the basis that we agreed to put a transcript of the hearing on the website of one of the solicitors so the public could see what had happened. But we were also fortunate in that an act was passed, the Coronavirus Act, I think is the name of it, which allowed the hearings to be broadcast. So the hearing was broadcast on YouTube, which I think is the first time that that's ever happened. And it raises, in terms of a trial anyway, but that too raises important issues, because is it really fair on witnesses that their evidence is broadcast around the world? And in my experience, YouTube is not being used anymore. And then what happens is that cases get listed, and then you have to write to the judge's clerk or some person in order to apply to listen. So you can listen to cases, but it's not being done on YouTube. What are the problems? First of all, it's not suitable for every type of case. If it's a very heavily contested factual case, it's going to be difficult for a judge to assess what we call the demeanor of the witnesses. There's also the point that it's quite stressful, eye strain, and tiring for a judge to have to look at a screen all day, which is another problem which has been mentioned. There is also, and I suspect, a problem which perhaps more relevant in the international law context, where one is dealing with parties who are not so well resourced? What is it if you're involved with a state who doesn't have the financial, the technology to put that, to do a hearing that way? That's obviously a point. And and obviously justice has to be equal. There has to be equal access to justice. And that, I think, is a consideration in play. I mean, the only other point I'd make before I pass over back to Attila is that the real problem as far as London is concerned, in England, is in the context of criminal cases and jury trials, because we found that the social distancing rules make it very difficult to get a jury of 12 people together, and that is the big problem. It's being addressed. There are a number of pilot cases taking place to try and deal with it, but that is where it's going. And I think what we're going to see now is that as the lockdown is starting to relax, as we've seen in your country, I think you're ahead of us, but the lockdown is getting easier. We're going to have what might be described as hybrid, is the phrase, the hybrid hearings, where instead of everybody working from their home, you might have a situation where you get the judge in court with perhaps only some of the counsel, and other counsel are in a different place, or that witness evidence is taken in a different way. So effectively, you're trying to replicate as far as possible all the advantages of a full hearing. But while the lockdown is still in place and the social distancing rules are in place, you're going to have a situation whereby you get, a situation which is not a normal trial, but at the same time, not a full virtual trial. And that's what I think we might be seeing in the weeks and months to come. Attila, is that enough of a introduction in terms of how these hearings are going, or would you like, for your purposes? Or
it is
that good enough?
Just perfect, as I thought it would. Thank you so very much. Very, very interesting. If I may add a parallel to what you've been saying about suitability of this virtual mode for purposes of transparency and need for confidentiality within the framework of a transparent setting. As it happened in person, we had a hearing before the International Tribunal for the Law of the Sea, parts of which required confidentiality. I mean, the whole proceedings were on streaming, and as much as the physical part of the hearings got closed doors, you wouldn't have that part on streaming. I suppose that a similar formula can be found so to accommodate transparency and confidentiality requirements on a case-by-case basis. I'm sure about that. But thank you very much again, and I'm sure someone will pick up parts of your remarks during the discussion. Now, the next speaker is Giacomo Aiello. Giacomo is a state attorney of the Italian Republic. In that capacity, he has served several times as a legal advisor to various Italian ministries, and particularly relevant for today's purposes, he has served as a legal advisor to the National Civil Protection Agency, focusing on the drafting of emergency decrees to be issued by the Prime Minister. That is particularly germane to our discussion. But I also wish to recall that Giacomo has been counsel for Italy in the jurisdictional immunities case before the ICJ, and a co-agent for Italy in the North Star case against Panama before the ITLUS. It's worth noting that Giacomo has served and is currently serving as counsel or agent for Italy in 11 investor state arbitrations. Without further ado, Giacomo, please, you have the floor.
Thank you, Attila, and good evening, everybody. Thank you all for the invitation to this interesting seminar. My intervention consists in a predictive analysis of the course of action that may rise before the European Court of Human Rights and Investment Tribunal as a result of the measures that individual states have taken to face the COVID-19 outbreak. First of all, state measures should be divided into two categories. To the first belong the typically emergency measures to contain the spread of infection, and that usually consist in social distancing. This category includes restriction on the movement, prohibition of assembly, requisition measures in use or expropriation of immovable or movable property, limitation of the right to confidentiality to track the movements of potentially infected people, suspension or the inevitable slowing down of a series of social services like the care of the person and the education sector. The second category includes measures to boost the economy severely affected by the crisis, result of the spread of the pandemic worldwide. According to the first category, the measures adopted by the state have been broadly the same all over the world, so that what varies is the intensity and duration of them. The measures falling into this category directly affect the fundamental rights of the person. The unjustified compression of this right may give rise to a dispute before the European Court of Human Rights. Article 15 of the Convention allows exceptions to the obligation arising from it in case of war or public danger that threaten the life of the nation. These include freedom of assembly and association and freedom of movement, for which the treaty itself expressly allows restrictions aimed at health protection. Only few countries have notified measures adopted to face the outbreak. I think, however, that apart from the notification by the states, the recurrence of the preconditions for emergency measure can be considered a well-known fact that was confirmed in the WHO statements on 30 of January and 11 March of 2020. However, member states do not have unlimited discretion because measures to restrict human freedom are tolerable only if they are of a temporary nature, are strictly necessary for the solution of contingent and unforeseeable problems, and are proportionate to their purposes, which must be defined in a transparent and non-discriminatory manner. The need to face the pandemic emergency cannot therefore become the opportunity for authoritarian and permanent revisions of constitutional principles and individual freedoms, as seems happened in some countries. When the dust settles and the turmoil of these moments ceases, the European Court of Human Rights will not struggle to find space for intervention. With regard to investment law, legislative measures to protect health may be important in application of police powers or the precautionary principle. In such cases, the settlement of the disputes will depend on scientific evidence, which will provide a roughly objective basis for assessing the reasonableness of the state measures from which it has resulted in damage to investors' rights. Investors may claim the measures amounts to an expropriation of their investment without respect for minimum standard of treatment, requiring the avoidance of manifest injustice or gross discrimination, or to a broader notion of the fair and equitable treatment. In justifying the need of its measures, the host state may produce scientific evidence or risk assessment that support the existence or the extent of the public health risks involved. I now want to deal with the regulatory measures in the second category, which are designed to contain the effects of economic crisis and which may lead to investment bias. The first comments on the subject have mainly taken into account the impact of measures in the first category on investment law and have assessed their compatibility in relation to the hypothesis of force majeure, state of necessity, and distress. In the light of international public law, these are the exceptions in which damage to investors' credit rights may be denied. It seems to me, however, that the measures in the second category deserve special attention. Only in the first quarter of 2020, GDP declined by 3.8% in the euro area, by 4.8% in the USA, and by 6.8% in China. It's clear that every country is facing an unprecedented economic crisis that will force at least choices of redistribution of wealth or complete revision of the macroeconomic objectives. In this area, government measures will need to be assessed not only from the point of view of the single state which adopted them, but also according to the fair and equitable treatment, since the overall legal standard for an action to qualify as a fair treatment is high, in particular because this determination is a balancing exercise between the investors' expectations and the host state's regulatory authority. The expression expectations refers to representation of future legal facts and acts with which foreign investors derive from the conduct of the authorities of a state and on whose basis they made their investment. The word legitimate means worthy of protection under international law that consider the state's sovereign regulatory right to modify their legislation. With regard to this issue, there are dissenting arbitration awards. According to a first opinion, to constitute a breach of the fair and equitable treatment standard, it must be shown that host states' conduct was manifestly or grossly unfair or unreasonable, was arbitrary or discriminatory, constituted a denial of justice in national proceedings of the host state, or that this one engaged in a willful neglect of duty or a willful disregard of due process of law. According to another approach, since the economic crisis is not a cause of force majeure, it's necessary to assess the level of the commitments to maintain the regulatory framework that the host state had taken at the time of the investment, regardless of the existence of a stabilization clause. When we talk about intervention on the economy, we must also consider the supranational framework. The current economic crisis has led to the adoption of unconventional measures also by European Commission, for instance, suspension of the fiscal compact and aid legislation, and the ECB renewal of the program for the purchase of government bonds without limits for junk bonds. This may also result in the involvement of the ESB or the European Commission, as happened recently in the case Nord Stream 2, in which the amendments made to the gas directive were considered by the applicant unreasonable, discriminatory, and issued in violation of ECT. EU member states have taken and will take initiatives which, in a line of continuity, have generally increased the assumption of golden power and public intervention in the economy. Since the pandemic emergency has symmetrical characteristics because it is widespread almost everywhere, at the same time has asymmetric effects, both in relation to the number of people infected and diseased, both for the impact on the economy of the countries involved. So it's to be expected that the more serious the local economic crisis, the more drastic the economic intervention measures will be. It was therefore a partial suspension of the principle of free competition, which was upheld by European law. This brings us to an unknown land, which may trigger multiple forms of reaction in relation to which the well-rooted principles of international public law may be inadequate for finding solutions. Thank you.
I had muted myself. Well, thank you very, very much, Giacomo. That was very interesting, particularly when you added the European Union litigation potentials as uncharted territory. We will see, we'll see. Now, we can complement the views of a practitioner from the state side with this scholarly approach on very much the same areas of problems by Federica Paddeu. Federica is fellow at the Cambridge Center for International Law in Cambridge. She holds a PhD from the University of Cambridge. She has published extensively in leading international journals worldwide, but I wish to single out her monograph, which is particularly germane to today's discussion, which was published in 2018 with Cambridge University Press, precisely on justification and excuse in international law, concept and theory of general defenses. Federica is a qualified lawyer admitted to the Caracas bar, where she has worked for Baker and McKenzie. Federica, thank you very much for being with us. You have the floor.
Thank you very much for the invitation. It is a wonderful distraction to talk about international law, given that the rest of the time I'm looking after two young children, which do not like talking about international law, it turns out. So in my presentation, I will be addressing in slightly more detail some of the questions that Mr. Aiello presented earlier, in particular going into the questions of force majeure and state of necessity. As a matter of personal note, I think I agree with his ultimate conclusion that these rules of international law are not actually adequate to address these kinds of crises. And I think part of the reason is that they were developed for a very different reason. Historically, these two rules were developed to address primarily man-made events such as wars or financial crises arising from wars and conflict in the late 19th century and early 20th century. They didn't really envisage the interconnected world that we have today. They didn't really envisage epidemics of this level. So I think that because of the foundations and the ways in which they developed, they aren't actually able to address this current crisis. Now, this is a very knowledgeable audience, as I can see. So instead of producing a sort of overview of the issues that might arise in cases of force majeure and necessity, which is probably basic and a bit boring, I thought that what I would do is just select some issues and perhaps dig a little bit more into them, go a little bit into more depth, or at least the depth that is allowed by 10 minutes. And then we can consider some of the other aspects in questions later. So I will address force majeure and necessity in investment law and human rights law. And I will start with investment law. Now, as we heard earlier, some bilateral investment treaties contain within themselves exceptions that are capable of addressing the current crisis. For example, some of the new generation BITs contain public health exceptions, which, as far as I know, have not yet been tested in international arbitration. So it'll be interesting to see how they are addressed. Old generation BITs do not contain this type of public health exceptions, but they often allow the exercise of police powers. And there's a historical case on the matter of police powers, which deals specifically with a question of an outbreak. This is the Bischoff case before the Venezuela-Germany Claims Commission that involved an outbreak of smallpox in Venezuela. And in that case, it was held that a state should not bear liability for exercising police powers in addressing the pandemic. So these exceptions are part of the sort of primary law regime, but this may be unavailable to a state, either because the treaty doesn't include them or because they might fail. So the question is, can a state then rely on customary international law to defend their actions? And so it is here that I think that the defenses of force majeure and necessity come in. Now, these are both defenses that concern non-performance of obligations as a result of supervening events. The defense of force majeure arises when a supervening event causes, in the language of the ILC, a material impossibility to perform. It has very strict criteria and in fact has often failed. Venezuela itself invoked the defense in the Alcoven proceedings, but it was rejected by the tribunal on multiple bases. Now, one area of difficulty that I see in invoking this defense involves the meaning of material impossibility of performance. What does this standard actually require? Is the material impossibility an actual impossibility to perform, or is material impossibility about a high degree of difficulty in performance? Now, the difference is important because when we talk about an actual impossibility to perform, what happens is that the supervening event prevents the state from complying with the obligation. The state has no choice about performance, and we will say in these cases that the state's breach of the obligation is involuntary, as the language of the ILC articles is. But if we accept that material impossibility has a lower threshold, as some scholars have argued, that is some high degree of difficulty, but not reaching the level of actual impossibility, then the state in essence has a choice. It can perform the obligation even at a high cost, or it can decide to fail to perform. And in this case, the conduct is not involuntary. It is voluntary, albeit the choice available to the state is constrained by the circumstances. Now, depending on which of these two views is taken, the public health or the economic measures adopted by states to address the pandemic may or may not meet this requirement. There is no doubt that the measures adopted are voluntary measures and that states have had choice as to their adoption. This is evidenced by the fact that they have been adopted in different ways, as Mr. Aiello was mentioning earlier. Some have adopted binding measures, others, like Sweden, have not adopted binding measures. And the specific ways in which these measures have been implemented have varied across states, both in their intensity and their temporal scope. So there has been some choice in addressing the situation. So if one takes the view that force majeure requires actual impossibility, then these measures would be outright excluded from the defense. So meeting this requirement will turn on the interpretation that tribunals will take about material impossibility of performance. And as I said, there's some debate in the doctrine as to what exactly it requires, and very little, unfortunately, by way of case law to address the issue. State of necessity is an equally, if not more strict defense. There is some more experience about this defense in investment arbitration. It was raised, as is well known, by Argentina in numerous cases, and was also raised by Zimbabwe in the von Petzold arbitration. The case law, I'm afraid, is not likely to be especially helpful, or on the other side, it will be very helpful to everyone, given that one can find in it anything that one might want to argue about state of necessity. The views of tribunals have been widely different, and so there's very little that can be said with any certainty about the defense of necessity. Now, one thing that I don't think will be particularly difficult is assessing the balancing of interests in any case involving at least the public health measures. In line with the Argentinian case law, I think it is clear that public health interests and the well-being of the population are understood to be essential interests of the state, and that when contrasted with the interests of the investors or of the home state of the investors, they tend to be understood as being superior. So the balancing of interest aspect is not that problematic. But there are other aspects about the defense of necessity which will be quite problematic. And I think one example of this is the question of the non-contribution requirement. The defense of necessity is not available to the extent that the state has contributed to the situation of necessity. The ILC articles explain in the commentary that the contribution has to be substantial, but that's it. They don't say anything else. So does this contribution require some degree of fault? Or is any contribution, including one that is based on good faith policies, able to exclude reliance on the plea? Now consider, for example, that scientists have warned for years about the risk of epidemics like this one. In the UK, there has been news, for instance, that Operation Cygnus from 2016 highlighted the likelihood of such an epidemic and pinpointed to specific aspects of preparedness that the UK needed to improve. Things like the lack of personal protective equipment, the shielding of care homes. And these have turned out to be specifically some of the Achilles heels in the UK's response to the virus. So they were warned, the UK government did nothing. Is this a contribution, or is this the kind of contribution that excludes the plea? Well, it's not clear from the case law. Some tribunals have attempted to limit the scope of this requirement by demanding that contributions capable to exclude the plea reveal some degree of fault or perhaps even some degree of intention. And I think that this is to some extent fair. If the ultimate goal of the plea of necessity is to protect higher interests, then surely we do not want to limit state in doing this, in protecting these higher interests, because they may have unwittingly or in good faith contributed to the crisis. But as I was saying earlier, the case law is not very clear on the specific requirement. There is no state practice on the requirement of non-contribution. This was added by the ILC during the drafting of this provision in the 1980s. So the historical practice that supports the customary status of the defense of necessity does not include this requirement of non-contribution. So it'll be interesting to see how tribunals address this issue. Now, turning to human rights law, I don't think these two defenses will be particularly relevant, and I think so for two main reasons. One, human rights treaties often impose due diligence obligations. So these are obligations of conduct, and they are limited by contextual variables. You know, there are obligations to make best efforts, and those best efforts are adequate to, are related to the circumstances. So in a sense, obligations of due diligence already cater to situations of impossibility. If the state is unable to behave with the required diligence due to some supervening event, then the obligation is breached to begin with. So there's no need to rely on force majeure in relation to those types of obligations. Necessity, I think, is also likely to be excluded because human rights treaties contain specific mechanisms that allow the kind of interest balancing that the plea of necessity is all about. So states, as Mr. Aiello was mentioning earlier, can derogate from some of their obligations in times of crisis. And of course, these derogations are strictly limited, and they must also be notified to the Council of Europe, like at least under the ECHR, sorry. States can also limit some of their obligations, and they can do so when this is necessary to pursue some legitimate interest. The limitations must be proportionate to the legitimate goal, but that they are nevertheless, they involve again this question of balancing of the interests in question. Now, the rights implicated by the public health measures, by and large, are rights that can be derogated from or that can be limited for public health reasons. So the rights to freedom of movement, freedom of assembly, private and family life, and religion. So I don't see that force majeure and necessity will play a great role in litigation involving these rights. Matters might be different, for example, when we're talking about the right to life under Article 2, and for instance, those triage decisions about who should require treatment and who should treatment be given to, because they have involved consequentialist analysis, consequentialist ethics that are not necessarily compatible with the way in which the right to life is framed. Now, the test for derogations and limitations, I should also say, is less strict than the test for force majeure and necessity. So the rights incompatible or limiting measures are permissible, and this is assessed on the basis of proportionality analysis. Whereas in the cases of force majeure, as I was saying earlier, one requires this actual inability to perform. And in the case of necessity, the measures need to be the only way to deal with the crisis. So states seem to have some more latitude under specific treaty mechanisms in human rights law that are under the customary defenses. So I think that this might explain also as well why some states rarely rely on the defenses in the law of responsibility in human rights contexts. Now, one interesting impact that I think that litigation might give rise to is about limiting the limitations, as it were. Both derogations and limitations are available to states to justify the rights incompatible measures. And it has been interesting to see that states have differed in their approaches. Some states have declared states of emergency and notified of derogations, whereas others have preferred to rely on limitations. Now, the choice between the two has some potential implications for the so-called normalization of the rights incompatible measures. States of emergency are by definition temporal, they come to an end, and so do the rights derogations themselves. Whereas limitations do not need to come to an end. Derogations are built into the way in which the rights work. They are not a way to restore a pre-crisis situation or a new normality. They are rather part of the ongoing application of rights. And indeed, if you think that measures that were unthinkable for us in January, the kinds of Wuhan-style lockdown that we saw in January, and we thought, oh, this is never going to happen in Western democracies because we value individual liberty, nowadays seem to be quite accepted by societies. And the risk is that with the limitation approach, if this becomes just part of our ongoing thinking about balancing of rights and balancing of interests, and especially if the disease becomes endemic or its eradication takes several years, this limitation might entail curtailment of rights that are here to stay. We have seen this creeping regulation by state and this intrusion into human rights in the terrorism context, where again, some measures that we thought would not have been permitted in liberal societies are nowadays part of the way in which we understand human rights and human rights discourse. And I think litigation about specifically the limitations will be a tool to try to prevent states from normalizing these limiting measures, such that, for instance, tracking apps on our phones must be eliminated, or the idea that states can track individuals must no longer be normal once the epidemic is over and we no longer need to be tracking and tracing individuals. So I think that there are different implications about the various mechanisms of force majeure and necessity in the human rights context, and I think that the built-in mechanisms to address emergency situations are perhaps more adequate to deal with human rights, but also have problems in themselves which might need to be addressed, and litigation might be an interesting way to do so. Thank you.
Well, thank you very much, Federico. This was as good as intense it has been. I'm sure that as far as the impact on certain defenses of the due diligence nature of certain human rights obligations are concerned, Professor Riccardo Pisillo-Mazzeschi will chip in during the discussion because he is the specialist of due diligence and positive human rights obligations. Now, you have been mentioning the ILC a number of times, and here it is. The next speaker, Dr. Aniruddha Rajput, is a member precisely of the ILC, United Nations International Law Commission, since 2017, and I may mention that quite formidably in his first year, he was elected chair of the drafting committee of the ILC. and he's currently a visiting fellow at the Max Planck Institute in Luxembourg, where I had the pleasure to share a room for a few months just before the lockdown. Dr. Rajput represents states and private entities before international courts and tribunals, and is currently a consultant on public international law and international arbitration at Withers in London. He has published extensively on issues of general international law, law of the sea, boundary disputes, international trade and investment law. I had the pleasure to take part in the launching event on a book that he just published on state regulatory freedom, published with Kluwer International, which is also very, very germane to today's discussion. And I may note that he has been involved in the drafting of the revised Indian model, BIT. Without further ado, Aniruddha, you have the floor.
Thank you very much, Attila. I should begin by thanking the Italian branch of the International Law Association, and you in particular for inviting me to be a part of this panel, and specifically to be a part of the Italian international law family. It's a great pleasure to be here. What I intend to do in the brief period of 10 minutes that I have is to touch upon what are the aspects of international trade law and some aspects which have been left by the previous speakers in relation to international investment law, which may be relevant in the current context. And I mean, of course, what might be the consequences which arise because of the COVID-19 crisis. One point which I think has come out quite extensively in the things that you said and Mr. Aiello said was there are two aspects of regulatory measures that we would see, or we could broadly categorize the regulatory measures which would arise in the future in two categories. First set of measures aimed specifically at responding to the pandemic, maybe in the form of lockdown or measures which were undertaken to resolve the emergency situation. Secondly, would be the measures which would be taken on a long-term basis in order to support the economy, in order to support public health, to put in some measures. So these are the two sets of measures which might be involved, two categories of measures that one can conceive. Of course, what would be the specific nature? It would be very wide, so it won't be possible to bracket it into any of the categories. Now, what would be the consequences of international law in relation to these measures which could be categorized in these two boxes, if one may call them? As was pointed out by Federica before me, that the position of customary international law in relation to necessity, force measure, is by itself a very narrow scenario, or even situation of distress, because distress involves actions by individuals for which are attributable to the state. So that may not be as relevant as one may conceive of it to be. But force measure and necessity are certainly the two important aspects of customary international law which would come to mind, and would of course be raised in investment arbitrations, not so much at the WTO, because the WTO, they're not so keen to rely on general international law. Of course, they rely on some general aspects like good faith, treaty interpretation, attribution, but they're reluctant to get into issues of necessity because they have their own entry route of Article 20, which provides for necessity, which is a different test altogether. So when we are looking at these measures from the perspective of necessity and from the perspective of force measure, we of course see that it is very difficult to meet the threshold standard. And as it is, the standard has been made quite dense. Of course, one could definitely argue that the situation that the states are faced with is such which threatens the essential interests of the state, because essential interest test, which is the requirement under Article 25 of the ILC draft articles, could probably be met in a situation of this kind. And then, of course, there's a question of whether this is the only measure which the state could have adopted, or it could have adopted any other measure, would be a matter which is open for debate. So customary international law does provide, to a certain degree, certain defenses, but as I said, they are fundamentally narrow in nature. And the tests appear to be quite high, and in the past, often they have not been met. Does that mean that they can't be met in light of the current crisis? Because as we see, the nature of the crisis is different from the crisis which have been faced in the past. The contagion effect is such that it's difficult to conceive that anybody who's sitting there would be completely insensitive to the situation which has unfolded in light of these circumstances. And then, of course, there's an element of interpretation. There would be an element of state practice and jurisprudence which would come into play when it comes to what would be the impact or what would be the defenses in relation to these measures. So one point which in my view needs to be highlighted is whenever the defense of necessity or a defense of force measure would be raised, it would be a situation of exception. That is a situation where a state acknowledges that it is in breach of a violation, but wants to put a justification and to get out of that obligation. So this one could call are, in a sense, defenses more in the form of negative actions or swords, to use the words used in the commentary of the International Law Commission, because they fall broadly in the category of countermeasures. And also, these are the set of measures which could probably fit in well for the first category of measures, where it is really about responding to the situation, responding to an emergency, rather than long-term measures which would obviously be undertaken. Those measures, in my view, would fall in a different domain altogether, and that is the domain of police powers. Here, the states would not be in a situation to say that we are defending a measure which was wrong in the first place. But here, states could possibly raise an argument that we undertook a measure which we were perfectly allowed to undertake under customary international law. And what is classically called the police powers doctrine, but often more regularly referred as regulatory freedom by in the decisions of international courts and tribunals. And the fundamental point, or the fundamental reason, or the whole substance based on which such a regulatory freedom is exercisable under customary international law is the fact that despite the presence of a treaty under which states have undertaken obligations, states can very well undertake regulatory measures in certain situations under customary international law, not in the form of defense, but in the form of an active right. And if we look, for example, the navigation rights case of the International Court of Justice, where the court said, even if there was a treaty which Nicaragua had entered into in relation to San Juan River, it was perfectly valid for Nicaragua to impose regulations which were necessary to conserve the river. Or if one goes back further, or rather much backwards, is the North Atlantic fisheries case, where again the arbitral tribunal said, despite entering into a treaty, the customary law right to regulate does not disappear. So that is definitely an entry point, or is probably an entry point for several states to say that this is an active measure rather than a defense under the categories of necessity or force measure. Now, regulatory measure doesn't mean that any and every measure could be justified. If you look at the state practice, the jurisprudence of investment tribunals, they have set it out quite clearly. As long as the measure is bona fide, non-discriminatory, and in public interest, the measure should be fine. Now, bona fide by itself means that there would be a need to investigate the intent or the objective behind undertaking such a regulation. That intent could be deciphered from the legislative history, discussions in the parliament. In the case of regulations based on EU advice, it would be those advices which would be provided, it would be scientific evidence. So that could be a basis to claim that the measure was bona fide, that is, it was taken with a good faith intention. The measure would have to be non-discriminatory. Now, here might be some problem, because there would be steps taken by states to protect domestic economies. And it would be valid for a foreign investor to argue that it is discriminatory towards me as a foreign investor because it does not include me. But there is a further argument, and I think that argument does arise from interpretation of notions of MFN, national treatment, which are classically known as the non-discrimination standards. So an interpretation of these standards, or the notion of these standards, could inform how discrimination is interpreted, which means that if a state decides to undertake measure to protect a certain group of industries and doesn't discriminate within them, then the question would be whether a state has discriminated within the sector. if a state could say that the sectors are non-comparable, or our measures are perfectly applicable within a certain sector within which we haven't discriminated, then it is possible that a state could defend its measure as a non-discriminatory measure. And the last and the most important aspect is public interest. And I think there would be little doubt about what is the involvement of public interest in these issues. And the threshold also in relation to public interest is much lesser. Because if one is exercising regulatory freedom under customary international law, the test for judging it is not the test of proportionality, which has been classically used under GATT, Article 20 jurisprudence. Under GATT Article 20 jurisprudence, a state has to positively show that there was no other measure available, or has to do a comparative weighing and balancing of different measures and to say, this was the best measure that we could have arrived at. So defense in the context of GATT 20 is quite different, because it, if one can say, funnels the defense further down. The customary law defense is further reduced in terms of its nature to a certain extent, although not as fully as one would imagine. There are several measures which could be very well defended under the GATT 20 exceptions. Because GATT 20 does allow, and there's a specific exception for public health under GATT Article 20 sub-article B. A state can very well say we took measures to protect the public. So all measures of public health would broadly fall in that category. What a state would have to show that these measures are not undertaken as a disguised trade barrier and are not discriminatory. The disguised trade barrier aspect can be further, I think, defended based on scientific evidence, saying that it was a health regulation and it was necessary to protect the health in the domestic economy, or economic measures. So in both respects, there could be sufficient basis to advance an argument in this regard. There could be issues in relation to the Sanitary and Phytosanitary Measures Agreement, the SPS agreement. Article 2 of the agreement does allow state to undertake measures, but the measures again have to be on a non-discriminatory basis. It is possible for states, therefore, to say, whenever they are undertaking health regulations, to say these regulations are for the overarching objective of protection of public interest and not discriminatory, or rather the objective is not to discriminate somebody who's exporting from another jurisdiction. So when we look at the whole gamut, in a sense, of the interaction between trade law and investment law, we see there is a sort of a balance whereby customary international law continues to function alongside international treaty law. If we look at, for example, BITs, they do provide for exceptions in the form of exceptions in situations of necessity. The Argentine BITs had a much lesser threshold of necessity as compared to the Article 25 ILC draft articles. So it was much easier to establish necessity under the BIT than under ILC draft articles. So states could definitely rely on their BIT if that has a sufficient defense. In the absence of that defense, the customary international law right to regulate is definitely there, which in my sense is much broader. Also, the test of review is much lesser as compared to treaty law. I think a lot of the answers there might lie outside the treaties and the interaction between treaty and customary international law. I think I'll stop there. Thank you.
Thank you very much, Aniruddha. Of course, you're most welcome to the Italian international law legal community. The next three speakers, discussants, are three representatives of that community. As much as they will certainly stick to shorter period of time, we might be a little bit tight for the discussion if we were to wind up at 7. So I think we can extend the discussion if anyone is available until about 7:15. Now, first discussant is Pia Acconci. She's full professor of international law at the University of Teramo. And she's definitely an authority in international economic law, both international investment law and international WTO. Without further ado, Pia, you have the floor.
Thank you very much, Attila. Can you hear me?
Very
yes. Well. Okay. Thank you. Thank you for inviting me to take part in this distinguished panel. I will stay in my 5 minutes, more or less, I understood. So I will propose a few comments, remarks on international trade law. As far as I understood, you think I might be able to do this, even if my specialization has been investment law over the last years. So, many states have adopted restrictive trade measures, in particular export-import restrictions and introduction of further technical requirements in order to cope with this emergency due to the COVID-19 pandemic. These restrictions have been discussed so far in articles, presentations, conferences, workshops, comments, blogs. After studying and researching on this topic, my impressions are that there are many open issues, many questions under an international regulatory perspective, looking at in particular the WTO system. But many scholars and even practitioners agree that at the end of the day, these restrictions are justified under WTO and under international customary law, as we already heard from the other speakers. Justifications can be found in the GATT 1994, in particular in Article 11, that appears to be the most relevant provision. In alternative, we have Article 20, in particular Article 20, paragraph 2, letter B, and we have also the possibility to resort to Article 21st, that is related to possible national security interest. So when we think, for example, of restrictions related to food products, agriculture and food products transactions, we might think that a state may be justified in blocking temporarily, of course, these transactions, in particular exports in these goods, because of national security interests related to national food security. But in the end, even states, I refer in particular to G20 leaders, have supported the legitimacy, the alleged legitimacy of these measures by, for example, publishing a statement at the end of March underlining what might be the relevant requirements for the legitimacy of these measures. And these requirements recall the requirements that have been usually considered under WTO law. So targeted measures, proportionate measures, transparent measures, temporary measures, measures that don't introduce disguised restrictions to trade and don't, for example, also disrupt global supply chain. And this might be a matter of discussion from the perspective of a traditional importing state, for example, again, of food products. But my impression is that in reality, states are not so willing of disputing, of litigating about these trade restrictions due to COVID-19. If we look at, for example, a relevant number of statements by states within international organizations like the WTO itself, in collaboration with the Food and Agriculture Organization, the World Health Organization, other UN organizations, we find that in my opinion, of course, states and international organizations are afraid that these trade restrictions might be only a starting point. So they support the idea of fostering international cooperation, international coordination activities, and they also have the support by international business communities, particularly by the International Chamber of Commerce, that have supported a few of these statements and is collaborating with the World Trade Organization. If we would like to insist on a possible litigation scenario, I would say that this scenario might be quite complex, especially speaking of this kind of restrictions, because of the crisis within the WTO system, in particular within the WTO dispute settlement mechanism due to the crisis related to the appellate body. But also, not only for this, but also because these trade restrictions bring about complex regulatory issues, and so possible potential complex cases, because we have competing interests at stake. If we look at these possible cases from the perspective of international law, only from that perspective, we find that we might have at stake international treaties on human rights, in particular as far as the right to food, the right to health are concerned on the one hand, and on the other, international treaties on trade liberalization. And as far as the WTO system would not be functioning, a consent-based alternative mechanism should be necessary, and this might be a further difficulty. So that is why I believe, and this is my final remark so far, that political solutions and not a politicization that might undermine the system and might bring about more uncertainty and even instability. But political solutions based on international cooperation, coordination through cooperation with the business communities, in particular transnational business communities, appear the best solutions. And this is my final remark, and thank you very much for your attention.
Thank you very much, Pia. I take note of your allusion to the fact that states would not be so keen on litigating cases just because they're complex. But I'm very much with you with the increasing trend of merging different negotiated, facilitated kinds of out-of-court settlement, which seems to be very much on the increase these days. And you're adding one voice to the choir, as we say in Italian. Now, thank you very much for that. The next discussant is Giovanni Zarra, Associate Professor of International Law at the University of Naples, Federico II. He holds a PhD with honors from the same university and an LLM with distinction from Queen Mary University of London. He has published 2 monographs. Just let me mention one, Parallel Proceedings in Investment Arbitration. And Giovanni has developed a robust experience in commercial and investment arbitration. Giovanni, you have the floor. I understand you're going to speak more about human rights litigation rather than investment law litigation. You have the floor.
Thanks a lot, Professor Tanzi. I'm grateful for having me invited in this distinguished panel. And actually, I was asked to discuss about both the European Convention on Human Rights and investment. So I took several notes during these very interesting speeches, and I will try to address a bit of both the aspects. Let's start with the European Convention on Human Rights, which has been called into discussion several times. And I think the first aspect that we shall discuss concerns Article 15 of the European Convention on Human Rights. Article 15 regarding the notification of derogation. It was recalled that several states chose not to apply this mechanism. I personally disagree with this choice because I think that when proceedings will start before the European Court of Human Rights, because we all know that proceedings will start, this would have been a good way to ask the court to lower the degree of control over state actions. Because we know that the sanction for not recurring to Article 15 is just that you cannot oppose the suspension of rights before the European Convention of Human Rights, European Court of Human Rights. Now, we know that at this point we will discuss about restrictions of rights instead of derogations, and restriction of rights are evaluated on the basis of the principle of proportionality. Proportionality is composed of three elements. One is idoneity of the measure to reach the objective that it has. Necessity, we don't have other less intrusive means to reach the same objective, and proportionality stricto sensu, which is a more concrete standard. We all know that the responsibility of states depends, can be created also by the actions of its regions, for example. And while I think that the Italian choices regarding the lockdown all respect the principle of proportionality, I have some doubts concerning some regional acts. I can refer to my personal region, which is Campania, where some very acts which can be compared to dictatorship, more or less, have been issued through some orders by the president of the region, who decided that nobody could go out of his personal habitation, also, for example, for reasons connected to a disease. So, for example, a cardiopathic could not go out for just a walk around, because in the event the police got him, he would have been put in mandatory quarantine for 15 days without even the possibility to go out for buying food. So, and regardless of the fact that this person was infected. Now, I guess that this is, of course, not a proportionate measure. And there are two possibilities. One is that before administrative tribunals in Italy, these decisions by the president of our region will be sanctioned. Otherwise, before the European Court of Human Rights, certainly this will be evaluated as a violation of the freedom of circulation and Article 5 concerning the personal freedom. And probably should Italy had actioned the mechanism under Article 15, this would have been a way of better defending itself. Moving to investment, we have two aspects. Ali Malek called up procedure. Procedure, we know that there are, one of the standards is given by ancestral rules of transparency. We know that this is a soft law mechanism, but it is recalled also by the Mauritius Convention on Transparency. Now, here we have two important elements. One is publicity of transcripts, and one is publicity of hearings. As to transcripts, the suggestion by Ali Malek sounds perfect, because if you publish the transcripts wherever, you satisfy the parameter of the unilateral rules. While as to publicity of hearings, here we have to discuss about a balance between the public interest in knowing what happens in arbitrations and the necessity to ensure fairness and efficiency. Article 6 of the ancestral rules tells us that the integrity of proceedings is one of the reasons why a tribunal can decide not to have public hearings. And Article 6.3 also mentions some logistical, generally speaking, reasons to derogate to the necessity of a public hearing. So here we have the, I think we are in the spectrum of an exception, and arbitrations could go on even without being public. Finally, moving to substance, and I'm trying to run. We have several ways that states can apply in order to escape responsibility. For sure, we have non-preclusive measures clauses within BITs. I know that Italy put a MPM clause in its model BIT. We discussed it at the ministry, and I perfectly agree with this measure. But very often, we don't have BITs with MPM clauses. So the possibilities are three. One is the right to regulate. Dr. Rajput extensively discussed about this. I agree more or less with all he said. I just would say that I'm not entirely convinced we are discussing about a custom, or at least the content of this custom is quite blurry, because we don't know, for example, whether indemnification for expropriation is due or not, according to this alleged customary standard. So my favorite choice is recurring to proportionality, which is for sure a general principle of international law, which allows a state to take measures which are proportionate to the goal which a state has. At this point, by applying proportionality, which is that element, but has been also applied in expropriation cases, I think, for example, about the Marfin and Cyprus recent case, we can have that states' measures are legitimate whenever they are proportionate to the goal they are aimed to reach. So proportionality could be a solution. And finally, force majeure. We know all that force majeure is quite a rare standard to be applied. We all find it in our books, but we never find it in decisions. I just would like to recall in this regard the fact that Rapporteur Roberto Ago in 1979 discussed about impossibility as to be divided in two categories. One was absolute impossibility, which is the one which is now present in the 2001 articles. The other one was relative impossibility, which takes place when state conduct is theoretically possible, but could not be pretended due to the circumstances of the case. And I think we are exactly in what Ago, in the situation that Ago classified as relative impossibility, probably due to the fact that he had a private international law background that put him close to private lawyers. And unfortunately, this solution has not been followed by successive reports, but I think that this could be an element for reflection, because this would be probably the best way to apply force majeure to a case such as this one. Probably because if this is not the case of force majeure, the category is useless in the end. Thank you.
Well, thank you very much, Giovanni, for having interpreted to the fullest possible extent your role as a discussant. Let me just, and thank you very much indeed, that will certainly steer further debate during the discussion, which I hope we'll have shortly. And just to say that I fully agree as far as the human rights part of your present reaction is concerned. I thought that Article 15 would have a compliance with the communication to the state of emergency to the Secretary General. The Council view would have been very much a sign of compliance with the rule of law, but the fact of the matter is that only some Baltic states, Balkan states, other Central Asian states, but neither Italy nor France, Spain, or Germany did it, and I think it gives us ground for reflection, for good or bad. Now, last but not least, Ludovica Chiussi Curzi is postdoc and adjunct professor of public international law at the University of Bologna, and a fellow at the Columbia Center for Sustainable Investment. She holds a PhD a joint PhD from the University of Oslo and Bologna. Her monograph on general principles of law in business and human rights is forthcoming with Brill Neyhoff. She has worked as a legal assistant in cases before the ICJ, ETLAS, and investment tribunals. Among his publications, she has shown expertise in conflicts between domestic jurisdictions in matters characterized by extraterritoriality. And in spite of Ludovica being the youngest speaker, she's going to handle the elephant in the room, China. So you have the floor, Ludovica.
Thank you very much. Can you hear me correctly?
Very, very well, thank you.
Thanks. Thank you very much, Professor Tanzi, for the kind introduction. I'm also very grateful to the International Law Association and to the organizers for this valuable initiative. So from the thought-provoking presentations of the previous panelists, I think it has emerged pretty clearly that the cross-cutting impact of the pandemic is one that bears on almost all branches of international law. So I will then take it from here and share some brief thoughts on litigating COVID-19 before domestic courts. Now, as we all know, the deadly spread of the virus at a global level has prompted arguments that China bears international responsibility for the pandemic. Allegations ranged from violation of the duty to notify the virus as set out in the WHO regulations to breach of the duty to contain it, and even allegations that the virus has been artificially created. So as the time allocated to my presentation is about 6 minutes from now, it seems wiser to immediately disclose my position on the possibility to assess and enforce such responsibility in domestic legal orders. In light of the customary rule on sovereign immunity, suing China before a domestic tribunal is not at present consistent with international law. There is currently no sufficient state practice and opinion juris to demonstrate that an exception to the norm of state immunity has emerged when it comes to violation of human rights, not even in cases of serious violations stemming from peremptory rules. So this does not necessarily mean that a development of international law so as to envisage such exception is not desirable or perhaps even foreseeable. So due to time constraints, I will focus on ongoing litigation before US and Italian courts. As to US courts, we've seen that before federal courts, there has been a wave of lawsuits seeking compensation from China for losses incurred as a result of the coronavirus pandemic. Class action lawsuits have been filed against Chinese authorities across various states in the US, such as Nevada, Florida, California, Texas, and Missouri. In the case of Nevada, for example, claimants allege that the Chinese government's cover-up for the coronavirus pandemic has caused unprecedented economic harm to small businesses. In Florida, citizens claimed that the Chinese government mismanagement of the virus caused physical illness and emotional distress to the inhabitants. In Texas, again, the complaint is instead both against the Chinese state and the laboratory in Wuhan, basically arguing that the virus was artificially created in the laboratory and accidentally released. So to these cases, one more should be added before US courts, and it's the one filed by the Missouri Attorney General against the Chinese Communist Party. And not only the Chinese Communist Party, but also, of course, the governments of Wuhan and Hubei province and the Wuhan Institute of Virology. So here the Missouri Attorney General alleges that during the early stage of the pandemic, Chinese authority hid the information, basically allowing millions of people to be exposed to the virus. Despite the specificities of each case, the elephant in the room remains basically the same. The customary rule of state immunity, as codified in the UN Convention on Jurisdictional Immunities, establishes that no state can exercise jurisdiction over another sovereign state. With specific regard to the US context, The restrictive exceptions have been incorporated in the Foreign Sovereign Immunities Act of 1976 and entails the commercial activity exception, the territorial tort exception, and the state terrorist sponsoring exception. So briefly, with regard to the first exception, the commercial activity one, it would require proving that China's activity was not iure imperi, that is basically not amounting to sovereign act. Furthermore, even in the light of the US jurisprudence, the commercial activity exception would only apply if China's actions related to the coronavirus had direct effect in the United States. So here,
the cut-off.
I think an argument we want to keep in mind is that, according to the interpretation given by the US courts, it is required that the entire tort occurred in the United States. So it would be very hard to demonstrate that that was the case in the coronavirus spread. I will not delve for time constraints into the third exception, that is the state sponsoring terrorism one, as China does not fall within the list, the 4 countries list that was issued by the US. So I think another point we want to recall is that Missouri tried to argue that the
it doesn't. I'm sorry, but you seem not. I can't hear. I can't hear Ludovica. Can anyone else hear Ludovica? No, no. I think there is
Poor connection.
Yeah, there's a problem of connection with her. Is not with us. Well, I remember during the last panel, which I moderated, Ludovica, I cut her off abruptly, and I felt very rude. And I'm sorry, the technology is not making up for Ludovica's injustices. So no. So we will read from Ludovica somewhere about this. Gabriela.
I'm very sorry, it was, can you hear me? Yes.
Yes.
I'm very sorry, it was a very interesting discussion, but I'm confident maybe Ludovica can resume the discussion with the public if anyone has the opportunity to intervene. But I would like to thank very much the panelists and the discussants. They shared with us very thoughtful reflections. And of course, these issues will continue to foster discussions and debates and hopefully not conflicts in the near future. Attila, do you think there is room for a very, very short debate? Because the public is very good. I've seen the names. We have persons from various countries, and well, I'm just sorry that they cannot intervene, but I think we do not have time.
As far as I'm concerned, Gabriela, I'm very pleased to make my time available to have the debate going on. I would like to see if there are requests for the floor.